good morning, students. Today, we're going to see yet another important topic under the tort law, which is the various kinds of liabilities. So, before looking into that, let's see what a liability is in the first place. As you all know, liability is something that attaches responsibility to a tortfeasor who has committed an act negligently or carelessly or with an intention that has resulted in certain damages to another person, or it has caused harm to another person, and it attaches a responsibility on the tortfeasor to compensate for the act so committed. The compensation could be in the form of money, material, which will be decided, on a case-to-case basis, depending on that specific circumstances. But today, the concept that we are going to deal with, the kinds of liability that we are going to deal with, it holds the tortfeasor accountable for the act so committed, even if there is no actual fault on the part of the tortfeasor. Meaning, even if he is not negligent, even if he is not careless, even if there is no intention or intention on the tortfeasor to cause damage to another person, the laws can still hold that person liable for the act so committed that has resulted in damage to another person. So this is where the concepts of strict liability, absolute liability, and vicarious liability comes into play. I will try to cover all these concepts in today's class, but if it exceeds the time limit, I think I will probably cover the remaining portion in the next class. Okay, so first let's get into the strict liability. What a strict liability is. So, strict liability, this is a type of liability where the defendant is liable for any harm or serious injury caused by their actions, regardless of their intentions or negligence. You might wonder, why would a law do that? Why would a law come up with such a doctrine, holding a certain person liable, even though he has not committed any, even though there's no actual fault on his place? Even if he is not negligent, even if he is not careless, even if he has taken all the reasonable measures, why would a law, brings this kind of doctrine to hold that person liable? There is a reason for it. The reason is that the law wants to promote those people engaging in these kind of, hazardous activities, in a certain kind of hazardous activities, to take extra safeguards to protect the public and the environment, which might get harmed, which might get damaged, or which might be harmed by the activities that they are carrying out. Which means, to apply these kinds of doctrines, that the strict, absolute, or the vicarious liability cannot be applicable in all the cases. For the strict and absolute liability or the vicarious liability to be applicable in a certain case, that case needs to satisfy few elements. You understand? Okay, only when it qualifies those elements, only when it satisfies all the elements which I'm going to state in a short while, that case is qualified enough for the strict liability to become applicable. Okay, so now let's see what are those elements. Then I will correlate those elements with an illustration, which makes it easier for you to understand this concept. You might find it, confusing or complex as I'm saying this, but when you see the illustrations, I think it will be easier for you to understand the concept. Okay, so what are those what are those elements? First one is that person, the tortfeasor, must be carrying out an activity which must be dangerous or hazardous. It's the first criteria. Second, there must be an escape of the dangerous thing. Okay. Third, there must be a non-natural use of land. Okay. Now, I'm going to correlate these elements with an example. This is the case of Reliance versus Fletcher. This is a famous case in the law of torts. So what happens in this case? This guy Reliance, Relan owns a land, okay, and he plans to construct a reservoir. Plans to construct a reservoir in his land through a contractor. Okay, so he's not constructing that reservoir himself. He's doing it through a contractor. So what happened during the construction process? This contractor guy, notices that an old pipeline is running under the land. And before that, I would say what a reservoir is. Reservoir is nothing which is similar. It's nothing. It's just similar to a dam that basically stores water. Okay. So coming to the case, this contractor guy, he notices that an old pipeline is running under the land, and he didn't do anything. He just left it as it is. He didn't obstruct it, or he didn't care to change the pipeline. He just left as it is, and he carried with the construction works. What happens after the construction? After a few days, the water packed in the reservoir breaks out because of the old pipeline. Obviously, it will break out. No, it broke out. Then it resulted in it resulted in flooding. It resulted in flooding in the adjacent coal mine of the plaintiff, who is Fletcher. Okay. So the water gets into the coal mine of the Fletcher. So what happens? Obviously, the plaintiff will approach the court of law. He approached the court of law and sought damages. Sought damages for the loss he has suffered. Okay. Now, before the court of law, Reland raises a defense that he was not negligent. That he was not negligent or careless. It was only the contractor who was negligent. Okay. But the court still held Ryland liable for the acts so committed. Court held Ryland liable. The reason being strict liability. The court stated that whenever a person brings something risky onto their land and that is likely to cause harm if it breaks out, in this case, it's the large reservoir. Okay. They can be held liable and they are accountable for any kind of damages which occurred because of it, regardless of whether they were at fault or not. Okay, this is what a court stated. So what happens? The court basically found this reservoir as a risky element, which satisfies the dangerous or hazardous element of strict liability. So it satisfies the first element. Then we have seen what is the second element. It's the escape of the dangerous thing. What happens in the Reliance case? That water which that water which the stored in the reservoir, which the court found it risky, escaped. Yes, when the reservoir broke, the water got into the land of plaintiff. So there is an escape of the dangerous thing. So it also satisfies the second element. Then what's the third element? There must be a non-natural use of land. In the Reliance case, there is a non-natural use of land, which is the construction of the reservoir. Yes, because the construction here, he constructs a large reservoir of water, which is obviously a non-natural use of land because it involved heavy risk to the neighboring properties. So it also satisfies the third element, which is the non-natural use of land. Hence, this is a this Relan versus Fletcher is a perfect example, perfect case of strict liability. So this is what the court observed and held Reliance liable. Okay, so this is what basically strict liability is. I hope it's clear. Now, there are certain exceptions to the strict liability, which means there are certain defenses that the tortfeasor can come up with uh, to not make him liable. Okay, so what are those defenses? Let's see. First one, it's the act of God. Second one, it is the plaintiff's consent. Third one is the act of third party. And there is also an other thing, other two exceptions, which is the statutory authority and plaintiff's own fault. Okay, so these are the differences that the defendant could raise in the court of law to not make him liable. Okay, what happens? First one is the act of God. Act of God. Let's see an example. So, no, before example, I would say what an act of God basically is. Act of God is nothing which is, you know, not under the control of humans. Okay, it may be like a sudden flood or a sudden storm or an earthquake or any other extraordinary weather events. Okay, so it basically means natural events that are beyond the control of humans. That is what an act of God is. You know, for an act to be qualified to be an act of God, it must be a natural event beyond the control of humans. So that's what uh, an act of God means, which is also it is also known as force majeure clause. Okay, so that's what an act of God is. So if a damage is caused by a dangerous activity, uh, but that was a result of an unforeseeable natural event, then the defendant may not be held liable. He can avoid the strict liability. Let's see an illustration for this. What happens in this case, Nichols versus Marshland. What happens? This defendant build a artificial lake. Artificial lake in his land, basically to hold the water. Okay, which is similar to the case of what we have seen earlier, Reland versus Fletcher. In that case, he basically built a reservoir. In this case, he just built an artificial lake itself, okay, on his property to store water. What happens? Due to an heavy rainfall, unfortunate heavy rainfall, that which is not foreseen by him, because of that heavy rainfall, the embankment, holding the water broke and resulted in flooding, into the land of defendants. in the land of plaintiff. What happens? Similar to the Raylan's case, this plaintiff goes and approaches the court seeking damages, but the court stated, no, the defendant cannot be held liable because the embankment broke not because of his fault, but it is due to the act of God. It is because of the unfortunate heavy rainfall that the embankment broke and the water entered the property of the plaintiff. So the defendant cannot be held liable. So this is the first exception. Okay. Now let's see the second one, which is the consent of the plaintiff. So here, in this case, if the plaintiff himself gave permission to the accumulation or the presence of dangerous material on the property, then he may not be held liable. On the property of the defendant, then such a case, defendant may not be held liable. And here, the consent may be expressed or implied. Okay, it can be expressed or implied. Consent can be expressed or implied. Okay, so let's see an example so that you will understand it better. What happens in this case? The case of Carstairs versus Taylor. What happens in this case? This guy, the defendant guy, is owning a property which is a multi-storied building. It has a ground floor and the top floor. What happens? This this plaintiff, is the Taylor here. Taylor goes and approaches Carstairs to rent out the ground base of his property. But the Taylor very well knows that the defendant has a certain water tank. It's basically doing some activity which which stores a lot of water in the first floor. So this Taylor guy knows very well that the defendant is conducting an activity which is related to water, storage of water, which is related to storage of water. Okay, storage of water, and he's doing it in the first floor. Okay. So now what happens? Due to some unforeseen event, the water in the first floor enters the ground floor and damages the property of Taylor. Okay. Now the Taylor goes to the court and approaches the court to seek damages. The court stated, no, Taylor, you very well know that the defendant was carrying out that activity before and you voluntarily accepted that risk and rented the ground base for your own purpose. In such a case, the defendant cannot be held liable because you voluntarily consented to that act. Okay. You can also think of another example, cricket. Now, say for example, during a cricket match, a ball hit one of the spectators in the stadium. Then in such a case, the spectator cannot sue the batsman because the spectator assumed the risk of getting hit by a ball. This is a presumed risk. So basically the plaintiff here consented and assumed the risk involved in the activity. So in such case also, the person who got hit by the ball cannot sue the batsman. Okay, this is also an example one can think of. So coming to the next two example, it is the act of third party. What happens? So in this, this exception basically states that if a damage was caused by the activity of a third party was not under the control of the defendant, then the defendant may not be held liable. Okay. Let's see an illustration for this. This is the case of Bob versus Tube. So what happens in this case? Again, it is similar to the Reliance versus Fletcher case. The definite as a reservoir in his land, and this reservoir gets you know reservoir breaks out and floods the sorry wait and floods the plaintiff property. Floods the plaintiff property. Okay. So what happens? The plaintiff goes to, again, as usual, goes to the court to seek damages. But here, the reservoir broke not because of you know any act of the box, or the maybe even in the Reliance case it was done by contractor, but that contractor was hired by hired by Reliance, so he has a certain comment over the contractor. Okay, so in such a case, that is a case which qualifies strict liability. But in this case, there is an act of third party who is not even relevant to the defendant. Here the defendant is box. Okay, the reservoir broke. The reservoir of box, the reservoir of box broke not because of his activity or any other person hired by him. Any other person hired by him. Okay. In this case, what happens? That was the reservoir broke by an act of a total stranger who the box has no connection with. Okay. So in such a case, if the reservoir breaks and the water gets into the land of the plaintiff, then in such a case, the defendant can very well raise such a defense, and the court will consider it, and it will not hold the defendant liable. Okay, so this is a exception, another exception. So coming to the next exception, which is the statutory authority. Statutory authority. So what happens? This statutory authority states that whenever an activity is done under statutory authority, the defendant, or basically the person who is doing that act, cannot be held liable for any damage that is caused by it. Okay. So this defense is applicable when the action of the defendant or mandated or authorized by law. Okay, this is the important element here, by law. If the act of the defendant is authorized or mandated by law, then the defendant carrying out that activity cannot be held liable for the damages that he has caused. Okay, let's see an illustration for this. Is the case of Green versus Chelsea Waterworks. What happens in this case? The defendant here is the Chelsea Waterworks. So in the Chelsea Waterworks, the Waterworks company, it has a legal duty to maintain a high pressure water supply pipeline. Okay, it has a legal mandate to maintain high pressure water supply pipeline. Okay, what happens due to certain reasons? The pipeline breaks out. No, okay, the pipeline breaks out and flooded the property of the plaintiff. the property of plaintiff. Now, when the plaintiff approaches the court to seek damages, the defendant can very well arise this defense of statutory authority, that he has a legal mandate to maintain a certain pressure, certain pipeline with certain amount of pressure. Hence, his action is sanctioned by law, so there cannot be any liability on him. He can very well raise that defense. So the defense here is statutory authority. Okay, and the court will consider such a defense. Okay, now let's see another row. Coming to let's see the last exception, which is the plaintiff's own fault. Okay, now this exception states that if the own action of the plaintiff contributed to the damage, then they may not be qualified to the compensation. Okay. This exception is especially relevant when the actions of the plaintiff were the direct result of the harm, such as when the plaintiff's property was damaged due to their own carelessness. Let's see an illustration for this. It's the case of pointing versus notes. What happens in this case? The oars of the plaintiff wandered into the oars of the plaintiff wandered into the land of the defendant. Okay, what happened? This horse wandered into the land of the defendant and ate the leaves from the tree, which was poisonous. Okay, ate a leaf from the tree of the defendant's land. Okay, which was poisonous, and subsequently the horse died. Now this plaintiff goes to the court of law and seeks damages for the death of his horse. The court stated that the plaintiff is not qualified for the compensation because the damage was caused by the plaintiff's own action, because it is the horse that went to the land of the defendant, for which the defendant has no control. Yes, so the defendant cannot be logically liable. So the court stated no liability for defendant. Okay, what's the reason? Plaintiff's own fault. Plaintiff's own fault. So that's all with the strict liability. Now let's get into the concept of absolute liability. This liability is also similar to that of the strict liability, but what happens in strict liability, at least the defendant can come up with some certain defense, because there are certain exceptions to the strict liability. But with absolute liability, there is no defense at all. Okay, here the defendant can be held liable even if the harm was because of a third party or because of an act of God or anything. If that act has committed a certain damage to the other person or the environment, and if that activity was carried by the defendant, then the defendant is absolutely responsible for that act, is absolutely liable for the act of the for the act so committed. Okay. So similar to the strict liability, you might wonder why would a court, sorry, why would a law come up with such a doctrine? This is because of, after many incidents relating to the hazardous industries, the victims who were suffered because of that activity could not get justice or compensation due to the defenses available in the strict liability, because the defendant comes up and say that we have took all the reasonable measures, and it was because of an unfortunate event that it happened, and the victims goes without any compensation. No, the court was not able to compensate the victims for the sufferings that they have endured. Because of that reason, the legal jurists evolved this concept of absolute liability. Okay, as I told you, this absolute liability is stricter than strict liability. There are no exceptions allowed. And unlike strict liability, which applies to hazardous activity, absolute liability is more constrained. It is applied to those activities which are ultra hazardous, just considered ultra hazardous. For example, chemical plants, nuclear facilities, etc. To see one of the you know famous case law or tragic incident where this concept of absolute liability was applied is the case of Bhopal gas tragedy 1984. I think most of you people would have heard about this case. In this case, the Supreme Court ruled that the industries dealing in hazardous substances have absolute liability. What happened in this case? That one night, on the night of December 1984, a gas leakage happened at the Union Carbide India. It's an industry, it's a plant, it's a nuclear plant in Bhopal. Okay, sorry, it's not a nuclear plant, it's a certain dealing with other certain chemical gases like methyl isocyanate MIC. Okay, so what happened? There was a gas leakage in the Union Carbide India plant, which is situated in Bhopal, and it has resulted in the death of over 3,000 people, and also it it had a long-term health problems for many more. Okay, so because of this disaster, after this disaster, the government of India enacted the Bhopal Gas Disaster Act 1985, and after which the case was brought to the court. Okay, so in the court, the government represented the victims and sought compensation. Okay, for the loss suffered by the victims. Here, the Union Carbide came up with a lot of reasons, like the accident was caused not by they being negligent or they being careless. It was because of a third party fault, or it happened because of an unforeseen situation. Everything, possible defenses it came up with. But the court said no. The court said no. You are still liable. Union Carbide is still liable. How the court came to such a conclusion? Through the doctrine, through the application of doctrine of, of doctrine of absolute liability. Okay, so this is one of the case in India which has applied, which made use of this doctrine of absolute liability. Okay, so let's see a few, as I told you, the elements of absolute liability. So first one, that there is no defense permitted. No defenses are allowed. Second, there must be an escape of the harmful material. as we seen in the Bhopal gas tragedy, what happened? There was the leakage of gas. So, such cases, the harm caused must be the outcomes of the breakout of hazardous substance from the premises of the defendant. That's what happened in the Bhopal gas tragedy. Now, third, there must be an inherently dangerous activity. It must be an inherently dangerous activity. So, in this case, in the case, that example is the Bhopal gas tragedy case that we have seen, they were dealing with the inherent dangerous gas, which is the methyl isocyanate. Okay, so what happens if the tortfeasor is dealing with an inherently dangerous activity? Then the absolute liability can be applicable. Let's see what are the few examples of activity that are considered to be inherently dangerous. Okay, so it includes the chemical manufacturing plants, which is the case of Bhopal gas tragedy. Second, nuclear energy production. Third, hazardous waste disposal. Fourth, mining operations. Okay, then there are, that's all. So these are the few examples, but it's not exclusive. But for understanding, we have stated these examples for you. Okay. Now, so that is all with the absolute liability. Now let's see the difference between the strict and absolute liability. Okay. So as I told you, although both strict and absolute liability inflict responsibility for the damage caused by the dangerous activity, these two doctrines have a slight distinctions, slight differences. First one, if you see, defense is available. Strict liability, of course, the defenses are available. The defendant can raise defenses like the act of God, third party fault, or the plaintiff's fault, etc. But in the case of absolute liability, there is no defense at all. No defenses are permitted. The defendant is totally liable regardless of any measures or external factors. Okay, even if it is the God of act, no, the person can still be liable. Now, secondly, coming to the type of activity carried by the defendant, coming to the strict liability, it is the non-natural and dangerous. Okay, coming to the absolute liability, it must be ultra hazardous or inherently dangerous. Okay, example which is the, as I told you, nuclear energy plants, toxic chemical manufacturing, etc. Then, if you see the purpose, it's more or like similar. Uh, to the in the case of strict liability, it ensures compensation for the victims of dangerous activities, but permits for a few defenses based on equity. But in the case of absolute liability, it inflicts an absolute responsibility for the hazardous activities to ensure that the victims are properly compensated. Okay, so that is all with strict and absolute liability. I think I won't be able to cover the concept of vicarious liability now. Maybe we will cover it in the next session. But I will just uh, give a gist of what a vicarious liability is. It is basically that in the vicarious liability, through this doctrine of vicarious liability, you can hold an employer liable for the act of an employee. Okay, that is what a vicarious liability is. Say, I'll also give an example. Say, there is this A, B, two persons are there. This A is the owner of a transport company. Okay, transport company. Then B is a driver in the transport company. What happens? This B was assigned with the task to transit a certain goods. And during the course of his employment, this guy, while transiting the goods, he do so after consuming alcohol. So he basically transiting the goods after consuming alcohol. Okay, and what happens? He rams into another person, rams into another vehicle, causing damage to the other person. Now, in this case, if the person for whom uh, uh, who has suffered the damages goes to the court and seeks compensation, the court can very well hold the employer liable for the act of the driver who is the employee, of him. Okay, because he does that act in the course of the employment. I will explain what is the meaning of the term course of employment in the next class. But I'm just saying for you to understand the basic concept of what vicarious liability is. Okay, so in this case, the employer can be very well liable by the court for the act of the employee. Okay, so this is the rough idea of what vicarious liability is. But there are certain elements, for that activity, sorry, for that circumstance to satisfy, which we will see in the next class. Okay, so that is all for today. Thank you. I hope my class was understandable. Thank you.